You stuck to the script. You stuck to the script. Good afternoon, everybody. How are we doing? Do I need to turn this off so it doesn't screech when I walk around? I walk around a lot. Okay, great. Okay. All right. How are we doing? Are we enjoying Chicago? Is anybody catching a Sox game or anything like that? I hope you guys are having some fun here and not just listening to the lawyers here. So, Eric, thank you so much for your very well-behaved and well-scripted intro. I was afraid you're going to tell stories of us grabbing beers and barbecue and whatever else happens after that. So, but thank you for that. And as Eric mentioned, so I showed up and I had actually just completed a stint as a labor commissioner. And so I oversaw OSHA enforcement for my state. And I went into private practice, back into representing companies like yours because you all run into OSHA. And when you do, it's not a happy day. And a lot of folks really step in it, and they can take a situation, make it a whole lot worse. And I talked about this before, and I won't talk about this too much today, but it kind of weaves in, is how you approach the agency. And knowing what's going on inside the mind of the inspector and the various people who have the citation and look at it all the way up the chain, you get a very different analysis. And so there's a particular issue that has a lot of people vexed, which is when you have multiple employers at a single work site, especially in construction. So I always saw, well, first of all, the lawyers would just drop right into this position right here, start throwing jabs, start throwing punches. And I said, you know what? That's not really the best approach usually. I mean, sometimes you can take a tough approach with the agency, and there's a time for that. I even had that. I was on the phone having a constructive conversation with an OSHA inspector this morning. And so there is a time when you have to kind of stand and fight because the agency often does get it wrong. I can tell you now it can be told. But the conversations that happen inside the agency are very important. So especially now, it looks like the multi-employer safety liability issue could be in play, depending on how a court case goes in the Fifth Circuit. So I really wanted to alert you to that, but also really to give you some general ways the agency looks at multiple employers at a work site. I want to give you some basic defenses that you can use and hopefully just avert the inspector and divert that person's attention to where it should go correctly, which of course isn't you, right? Right? Right. And also to give you some practical tips, things to think about right now, things you can go home and do the instant you get back to work, things that you can implement to make sure that you're not necessarily on the hook if somebody else on the work site screws up. And that is something that, hopefully these are some steps that you can take so that you can kind of inoculate yourself in case OSHA shows up. I got to tell you, when the inspectors show up, they love to use this shotgun approach. What do I mean by shotgun approach? Somebody tell me. What's that? Close. Do you have stress? You don't? Oh, okay, I have some knickknacks. I'm going to give these away. You guys thought that I brought my work with me. I was going to bill an hour or two while I present to you guys. I actually have knickknacks. I'm going to jump down here. Okay. Did I violate a standard right there? Okay, have a notepad. There you go. I've got goodies, guys. I'm going to move around, by the way. I'm not going to stay up there this time. What shotgun approach? When an inspector shows up. Yes? Yeah, they show up. Do you have stress? I got stress balls. I got a lot of these. They're very cute. They got blue hair. The texture of the hair is almost like mine. Absolutely. Yeah, they use the shotgun approach. So when the inspector shows up, they hit everybody in front of them. And they don't know what they're hitting or why or who. And they're not necessarily thinking about the law. They're not necessarily thinking about who has the appropriate defense. They're just trying to hit everybody. Because if they see something and somebody's in danger, the agency doesn't like it. So use the shotgun approach. Well, that's a little sloppy, I think. I don't think that's very precise thinking. And so I want you to do the precise thinking now to make sure you're doing what you need to do in case you get hit. Where's my clicker? Oh, here it is. All right, let's proceed. Okay, first of all, What I'd like to do, I can't be your lawyer, at least not for the next 45 minutes. 45 minutes, I can't do it. I can't answer all your specific questions to your situation. But I can give you some issues to identify when you're working in a multi-employer work site, some issues to identify before the inspector shows up, and also to raise some issues for discussion. I hate talking. I know you don't believe me. I hate talking. I'd rather have a conversation with you guys. So by all means, chime in. So I just want to make sure, I'm not going to answer your questions, but I do want to spot some issues for you. I can't give you legal advice. Sorry. I can't possibly do that in this time frame. A couple things to keep in mind. I'd love for you to walk out with a very crystal clear understanding. I do this, I'm okay. I do that, I'm not. But the rules aren't quite so crystal clear. In fact, it really depends a lot in terms of where you are, what law applies, and it differs from state to state and circuit to circuit. It can depend on who you get, the kind of inspection you get. Sometimes it's not entirely clear who's your employee and who isn't, even if you think that that's clear. So unfortunately, when you come out of this, it might be clear as mud, but I want to give you at least some guidelines to keep in mind. Every fact pattern is unique. So I know these are a lot of disclaimers here, but a little twist of the facts that you never thought would affect your case really can. So I can't tell you that every fact pattern, you get a different result. So just keep that in mind. And also, the law is developing. And you thought, okay, OSHA has been around since how long? Who knows how long OSHA has been around? Who said 70? Who said 1970? The OSHA Act? Yes. Oh, wait, I got to pick between you guys. Yeah, when the OSHA Act passed, and then, yeah. Since then, who was my first one? Over here somewhere. I got to go. Okay, I'll give you both a stress ball. Do you have stress? Okay, I got lots of it. This is a break for me. Isn't that sad or what? So you thought that since 1970 that the law was there, it's in black and white, you know what it is, the regs got passed, and it's all, no, the courts are still tangling with this stuff every day, and they're changing the law, and just when you thought you knew it, then we change administrations, and everyone gets whiplash, and we're in a whole new world, right? So it really depends. Things just have to wind through the courts. So folks like me, we're constantly ginning up issues, and usually we're trying to tangle up OSHA. So things that I'd like you to expect in terms of what we talk about today. Industries that are at risk. I'd like to talk about when OSHA makes an employee your responsibility, even if you don't think of that person as your employee. When does OSHA issue the multi-employer citation as opposed to just hitting one employer? Choosing safe and dependable contractors for your multi-employer work sites so that you can show that you've done the diligence you need to do to make sure that you have a safe workplace. We'll talk about record keeping. Who enjoys record keeping? Okay, at least you're normal. I actually kind of like this stuff. I'm a bit of a geek. So let's talk about the industries at risk. The biggest one that we see, at least in terms of my firm, is construction. OSHA says that about 46% of the accidents or the injuries and the fatalities are coming out of the construction industry. No big surprise there. So that's really huge. There are multi-employer sites at manufacturing sites. Energy and utilities is really big. I've got an energy company, and they're constantly getting hit for the crews that they send out, the independent contractors that go out and work on their behalf on utility poles, in electrical work, et cetera. And they're always getting hit. And they're saying, it's not my employee. Why am I getting hit? OSHA goes after the employer, but it just keeps coming back to them. And I'll explain why. And chemical is really huge. And of course, when there was a big, huge explosion in Texas and safety process management came on, and that's been a huge emphasis for OSHA. And of course, in those work sites, you just have a lot of different pieces and a lot of different moving parts, and it can be a lot of different employers. So let's jump in. Okay. Quick history. What is this language from? What's this language from? Yeah, who said the OSHA Act? All right. You look like you like pens. You like pens? That's okay, that's not good. Yeah, you're supposed to be taking notes on every syllable. This pure wisdom, right? I like to tell myself that. My wife thinks otherwise. There you go. Absolutely. Good to see you. So, check this out. I'm going to try the pointer here from, let's see, can I use the, yeah, that worked. All right. General Duty Clause of the OSHA Act. I read this 100 times and I thought I knew what it said. Doggone it. Every time you read it, you see something different. So check this out. Each employer shall furnish to each of his employees employment and a place of employment, and I italicized to each of his employees and a place of employment for a reason, which are free from recognized hazards, etc. Now, your employees are working at his site. Are you on the hook for his employees? Looking at this language, what does the language tell you? Yes or no? Yes? Yes, you're correct. Why? Shall furnish to and a place of employment free from hazards, etc., and shall comply with OSHA Act standards promulgated. Do you have stress? You don't look like you're having stress right now. All right. I'll give you a notepad. All right. Gentlemen, your employees work at your work site. Are you on the hook for his employees? Yes. Anyone say no? Who says no? I'm coming your way. Tell me why. I'll give you a hint. Plain reading. Did you get nominated to the Supreme Court? Who's? I was asking if you got nominated to the Supreme Court. Plain language of this statute. Oh, you have a brother-in-law who's a lawyer? So sorry. Your brother-in-law's on... I was going to get your card. I'm like, wait a minute. That's impressive. Oh, my gosh. I'd be dumbing down this group. I just asked the same question twice, and I got 2 answers, and you both got a prize. I mean, am I just being... Is this a big giveaway if anyone opens their mouth, or what? Why are both answers correct? Yeah, right. You got judges out there, and they get it wrong sometimes. And you know what? They're having a big, huge debate. So now, that's what the debate is right there. So does this mean, and I can get hyper legal on this, but I probably won't. Stop me if I do. But each of his employees, my employees, not yours, mine. And none of you are on the hook for my employees. Keep in mind, this is an asterisk. I'm sorry? Keep in mind, what you call an employee may not be an employee. And someone might become your employee even if they're not a W-2 and they're not getting your benefits. But sometimes if you take, this is a whole different, we can spend an hour on this subject, and we can spend days. If you're taking control of somebody, if you're providing the license, if you're providing the materials, you're doing the training, the day-to-day stuff, then someone you call a contractor might be your employee. I'm just going to leave it there. I don't want to open up that huge can of worms for this. I want to get into multi-employer. So that's the reading of that language. But then a place of employment. A place of employment is anybody's there. Anybody who's working there, no matter who they're working for. Clear as mud, right? That's what the debate is, and that's what's happening right now. This is happening right now. How long has the Act been in place? I think 1 or 2 years longer than I've been on this planet. No, I'm slightly older than the Act. Yes, barely. But that's a big, huge debate. So I'm going to walk you through a quick little history of what OSHA's been doing. Now, did OSHA get easier on the issue, or did they get tougher? Yeah. Who said tough? Who was the first one? Good. I got to make my travel light, so I got to give away stuff here. Oh, and by the way, I brought folders, and if you'd like to take my information on the way out, stress ball? Absolutely. Okay. There you go. All right. It wasn't meant for that. By the way, this is not happening at the workplace. This is not an OSHA violation. So, you are on a detour. You are not at work. Okay. Now, this is a lot of words, and I'll just walk you through it. I won't make you really read it. Okay. So, in 1971, the Secretary of Labor put out regulations, and really at that time, it was looking at construction only. So really, this reg has to do with just construction, not the other areas. So we're in 1926 land. So it put out regulations trying to clarify the rule to make sure that the more expansive reading of it is the one that applies. So that was OSHA's first attempt, places of employment, and really using that as a basis to go after other people's employees at your work site, if you're a GC. Then in 1994, and so there were court decisions. There was one in 1976 that affirmed that OSHA's reading of the rule. 1994, then OSHA once again clarified. I love it when OSHA clarifies stuff. It always gives them more authority than ever before. In the field inspection manual, and that's where it started to say, okay, anybody who creates the hazard, any employer that's controlling the work site or correcting. So not just exposing. Exposing was the language in the original OSHA Act. Now it's creating a hazard, controlling the workplace, correcting employers. They're on the hook as well. So in 1999, OSHA put out a multi-employer citation policy. Who's read that policy? Oh my gosh, I feel. Do you have insomnia? Did I give you something already? Oh, pen? All right, there you go. Yes, sir. Okay. Back there. I'm unloading stuff. Get it while it's hot. Did I get it? I already got you. Plus, I'm afraid you might chuck it at somebody else. Yeah. So, now keep in mind, and this is another subject, but as I've said before in another conference, it really depends on where you are. So this is OSHA's directive, federal OSHA. In half the states like mine, they may have their own state law. They do have their own state law, and they may use these directives, or they may not necessarily, but generally they do. But just keep in mind that in half of your states, there's little nuances, little twists. They might go in a little bit of a different direction. Clear as mud? So let's move forward. Okay, so that's the history, and that's how we got where we are. Let's talk about OSHA's policy and how it looks at the issue, okay? And this is all in the guidance. This is good. If you guys haven't read it, then I'll just give you a quick synopsis. So there are two factors OSHA looks at. They look at your role as an employer and what the duty of care for you is, okay? So let's look at the most basic one. Okay, so here are the four categories: creating, exposing, correcting, controlling, all right? And now let's look at each one of them. Creating. If you create a hazard. So it reminds me of a case where I actually was assisting a subcontractor. It's a terrible case. It's really sad. So the sub shows up, and the GC covers holes in the roof with material that looks like plywood but doesn't have anything like the strength necessary to sustain weight. And so they had worked together for years. They had worked together on this particular project for months. And so what happened was they walk up and they do part of the job, the sub does part of the job, takes a break, goes get some materials, and in the meantime they cut holes in the roof, did not tell the sub, and then one of them walked up and fell through, and it was a long drop. It's a really, really sad case. And so we're in the middle of that, and OSHA hit both with a citation. And so there, it's saying, well, my client, the subcontractor, exposed or created the hazard. No, they didn't. It was created by the GC that was already there and didn't tell us about it. So there's no creating the hazard. Now, had it actually cut this hole and then one of its employees dropped, then it would be on the hook. So, in scaffolding, maybe creating a hazard is if, let's say, you are mixing different parts that look and seem entirely identical but don't necessarily have the same qualities or strength or the qualities as each other, and then something breaks down and then you have a collapse or something. So that might be an example there. So that might be an example of creating a hazard, or poor engineering, or it could even be as simple as just sending folks up there without the proper fall protection, you name it. So that's creating. So what do you do if you're the creating employer? If you create hazards, what do you do? Well, if you can abate the hazard, what do? Somebody knows. You what? Yes. I'm sorry, he was first, and I don't think I got to your side of the room yet. You abate the hazard. What if you can't abate the hazard? What if you don't have capacity? We what? Report it? Yeah, you tell somebody. Is that what you meant, sir? Yes, warn, right. Good. So you ask the controlling employer to fix it. All right, so the controlling employer is the one that, or the creating employer, you create the hazard. You make sure that the controlling employer that does have capacity to fix gets it done, and quickly. And you have to inform others, you inform your employees, and alert everybody else in there on the work site as well. Anyone who can be exposed to it, even if they're not necessarily there all the time. Using reasonable alternative protective measures to protect others. So maybe if you can't put the trench box in there, you at least box off that area so nobody goes in case there's a trenching incident, something like that. Exposing. So this is pretty easy stuff. I mean, this goes back to the original act, the original OSHA Act. If you expose your employees to a hazard, of course, you're on the hook for it, even if you didn't create the hazard. So you can have, let's say you are, who's a foreman? Anybody a foreman, supervisor? No? All right. Let's say your foreman is walking around, and I have a case I'm working on right now, and I just went out to the work site, and the foreman is out there, and he has guys working up without fall protection on, and so my client gets hit with a citation. And, well, it's about to get hit. So, but he sees a lot of this and not a lot of fall protection. Well, the foreman they only have one employee on the work site, and the others are independent contractors. That point got kind of lost on OSHA. They're hitting my client anyway, because it's not creating a safe workplace for that one employee who's there to supervise the independent contractors. So OSHA might have a case. I think they kind of do in some ways, but I can defend in others. So he's walking around. Can OSHA prove that he actually saw these guys up there working without fall protection? Probably not. Probably not. So that's actual knowledge. So if you don't have actual knowledge, what other knowledge is there? What's that? Did I hear constructive? You said constructive, didn't you? Yeah, all right. Help me unload stuff, please. Constructive knowledge is, look, the guy is out there every day. Did I give you something already? Yeah, oh, man. You guys are smart being in the back. But if you're there and he's walking around all day, every day, he probably saw it. Probably. So they'll say you had constructive knowledge, you knew or you should have known. just by your business, by the way you run your business. So you could have discovered this hazard with reasonable diligence, even if he didn't actually see it, even if he's just kind of sitting there because in the office because the AC is going and he wants to read Sports Illustrated or whatever. Had he been reasonably diligent, he'd have seen this guy doing this, okay? And OSHA's going to get you for that, all right? So that's exposing. Correcting is much more narrow. Are any of you a correcting? Well, maybe we should talk about what correcting. Well, I'll go and ask. Would any of you consider yourselves a correcting employer? I don't think so. I mean, you build stuff. But if you have correcting, who has a correcting employer on a work site? One that is tasked with abating hazards, identifying and abating hazards. I'm sorry? The safety? Yeah. Yeah. That's worth a pen. So, I'm sorry? Well, yes, but they're probably going to be deemed controlling. But yes, they'll have correcting among their duties. So, correcting employer, let's say, if you're engaged in a common undertaking with the exposing employer, you're not necessarily exposing anybody to the hazard, but, was it you, sir? You already have stuff.
It's the owner's responsibility, ultimately.
You got one of everything. So, yes, so controlling employer usually will have correcting responsibility. But let's say your GC doesn't have the expertise necessary to control, for example, the railing here, okay? So the correcting employer might be someone who is responsible for abating the hazard and working on the same work site, but maybe that's all that employer does. It's your distinct, unique role to correct hazards, to make sure that this system is working properly, and that's it. And some of more complex work sites, and I'm sure you work on many of them, may have exactly that. So it's a duty to make corrections. It's not to monitor or enforce OSHA compliance, not necessarily, but of other employers, but you are to correct the hazards. You probably are telling folks what they need to do to comply while you're out there. So let's give you a for instance. So let's say a sub is doing the brickwork and on a construction site, and it hires a sub for the sole purpose of doing this guardrail work and maintenance. Now, there's a gap right there in the guardrail. Dun, dun, dun. Who's the correcting employer, the sub or the sub-sub? Yeah, the sub-sub. I wish I didn't have to keep running back. Oh, I should have had you guys come up here. All right. Who's the first to answer that one correctly? You were? No? Fess up. Come on. Who has stress? Here you go, sir. You have stress? I know you do. I'll save two for you. So, the sub-sub, and the distinct role is to fix that railing right there. And so again, it doesn't necessarily have to take over all OSHA compliance, but it does have to fix the problem. Common undertaking with everybody else on the same work site, not somewhere else, responsible for correcting the hazard. And how many of you do we have general contractors here? Anyone? Yeah. Well, I was going to mention that making sure, actually, this applies to you as well. If you have a sub working under you, just to make sure that those subs are responsible for their own OSHA compliance, not just in the contract, but also in daily practices. The controlling employer, and this is the good one, okay? This is the controversial one. This is the one that's getting litigated. Who's controlling? General supervisory authority over the entire work site. No matter who's on your W-2, you're in control of the entire project. You can correct violations or you can have them corrected. You're monitoring the employees. You're enforcing the employees' compliance. I told you before, if you have a sub and you need to ensure that it's in the contract that your sub is responsible for their own OSHA compliance and abating hazards, that's great. And I love documents to prove my case. But please don't give me bad facts. Don't put in the contract and say, you're in charge of your own safety compliance, but you're showing up every day, and you're directing everybody, and you tell them what to do, and don't do it this way, and no. Please, either take control and take responsibility, or don't. And I'm not saying do nothing if you don't have control or authority. You can, if you're a controlling employer, stop work. You certainly should tell your sub, hey, and have a guy or a person, a woman, somebody who you can call up and will quickly shut down work and correct it ASAP. Do that. But don't take control over the daily operations in doing so, because then what might you unwittingly become? It's 3 syllables. Somebody can shout it out. Controlling employer, right. So if you want to be controlling, great, and you're responsible. If you're not, you want to make clear both in your contract and your ordinary practices. So the reality on the ground, you're taking reasonable care to detect violations. You're taking measures to discover hazards and correct them. So it really depends. You're taking reasonable care, and that's for the controlling. It's a lower standard than the standard for the exposing employer. So, and that really depends. The reasonable care can depend on if it's a huge project, if it's a really complex project. It can depend on the nature and the pace of change. If it's a fast-moving piece and a lot of different contractors are going through there, and you have no idea what the expertise of that contractor is, then it can be very different. You may not have nearly as much reasonable care to do. And also, if you happen to know that your sub has a poor safety history, it kind of puts you on the hook for when the inevitable occurs. And that goes more under helpful tips. So, when I say GCs being controlling, prime subs often can be controlling too. So is anyone ever a prime sub? Nobody? No? Okay. Well, I'll just leave that as FYI. So, but OSHA can cite the GC and the prime as well. All right, let's talk about defenses. All right. It wasn't me. I didn't create the hazard. I didn't have any authority to fix it. I have no abatement authority. I notified the other employers about the hazard. I told the employees how to recognize the hazard, and for the exposing employers, well, I took other means to protect them. I moved them out of the work site. I blocked it off. I got somebody in there who has the competency to deal with this hazard. I did something else. These are all viable hazards you can use if you get cited. I'm not saying you won't get cited, but these are defenses that you can use if you are. And they've been recognized. All right, let's take a look. Controlling. This is the controversial stuff right here. You remember that debate we had when we had 2 different people and they were both right saying the opposite thing? So in the Fifth Circuit, and the circuit courts OSHA applies the law of the circuit that it's in. So what state am I in? Where are we now? Chicago, Illinois. Yeah, sorry, I travel. So the circuit we're in here, maybe OSHA follows the law of the circuit here. But if you go down to Texas, you may follow the law there, and it might be different. And so that's what's happening here. So in the Fifth Circuit, there were other cases that upheld OSHA's multi-employer citation policy through the years. The Fifth Circuit's doing something a little different. And so I mentioned that, okay, so this is a case where the employer, just like my client, had one person there supervising independent contractors, and so the contractor was working underneath in a trench that wasn't shored. There was no box, there's nothing. So clearly exposed to a hazard, and that employee did nothing. And so the owner, the general contractor, got cited for folks that it said, hey, not my employees. Fifth Circuit said, you know what, you're not controlling. So it said that the regulations serves protecting an employer's own employees from workplace hazards. So there you have several circuits that are going one way, upholding OSHA's theory, but another saying, you know what, OSHA, your multi-employer citation policy, that ain't law. That ain't law in the Fifth. Now, that is up on appeal from the Review Commission to the District Court, and so that's what the OSHA Review Commission ruled. So now this is being briefed before the Fifth Circuit. And if the Fifth Circuit agrees with this, then you may have a split in circuits, and then who knows? Maybe ultimately it's something that has to be decided by the Supreme Court. So, but two of you were right in opposite answers. This is what's playing out in the courts. So actually, maybe next year when we get together, we can see who was right and who was wrong, if it actually goes up to the Supreme Court or in the next couple years. And if not, maybe you guys can arm wrestle. I don't know. Work it out between yourselves. Yes? Did I have a question? What's that? You're going to wrestle? I don't know if I want to be there for this. I guess I have to. I obligated myself, right? I mentioned that the state plan states do their own thing. So, for example, in my state, we have a Court of Appeals, and it looked at this very issue, and it went against what my agency loves, the multi-employer citation policy, and it got the smackdown in 2005, in this case here. And so, and the funny thing is that it still follows the multi-employer citation policy to the T and still hits people, even though there's good law running to the contrary. And when I told you that OSHA often gets it wrong, yeah. And everybody thinks that this inspector and everybody inside the agency knows the law. I don't know about that. So it's worth fighting these sometimes and calling the agency to task. Yes? Can I back up? I hope so. There you go.
How do you resolve the state rulings? Does that go into federal court somewhere along the way? Or?
The state?
Yeah,
No.
a number of state courts that rule, and it says your mixed record. How does it finally get resolved?
In the state. So this could have gone to the Virginia Supreme Court, and there it would have stayed because there's no federal issue involved.
So you could have Virginia going one way and Nebraska going just the opposite.
You really could. I think Nebraska.
Wyoming.
Yeah. So yeah, you could absolutely have that. So, I'm sorry, when I said it's going to be clear as mud, that's where we are. So, let's keep going here. Oh, I got a question from somebody about temporary or leased workers and the obligations in dealing with them. So, generally, OSHA looks at your temp workers or your leased workers as yours if you're the host employer. On occasion, it might say that the temp agency or the company that leased the workers to you also is on the hook, but it really depends on who has control, day-to-day stuff, and usually that's the one on the ground, and usually that's the one that's the host employer. So, and it just depends on a number of factors, and the control, if you have the expertise or knowledge in the industry. So if you have leased workers or temp workers that come and help you put in a scaffold, they're not on your W-2, but you got them maybe from a temp agency, probably going to be your employees. So, that's just, it's a headache, but, the agency is saying, look, I got to cite somebody who has control over the work site. Minimizing exposure. I told you I'd give you some practical tips before we left. So, and I can give you a copy of all this to take with you. I can shoot it to you if you'd like me to. Whoop. So, having a written safety and health program and performing your hazard assessment of the work site, defining the scope of your work and your contracts, who is doing what. Got to define that in the contracts from the outset. And don't let those things just get dusty and sit. And don't write the contracts for every work site and every work site's different, you know that. You have a different mix of contractors, you have a different hazards, you have all kinds of different circumstances. Maybe somebody's reputation or their practices are not as good as they used to be. So just having one that sits on the shelf and collects dust for all work sites, I don't recommend it. And just keeping communications with your workers and with each other contractors. So those, and just keeping in mind the practices you have to engage in to make sure that if something bad happens, we know who's responsible. And everyone's going to give the same answer to the OSHA inspector when they get pulled aside to do interviews. I like separating things at multi-employer sites. Separate by time, separate by space, separate by task, separate by your expertise. Separating that out so that it's much more clear to an inspector, even what clothing you're wearing in the uniforms. That's a great idea. So that OSHA inspectors are not always the most, shall I say it, precise of thinkers. So they just like to use that shotgun approach. Don't let them. Make them aim the bullet where it belongs. So separate your recording and your reporting of your own employees. Include exculpatory clauses in your contract so that you're not on the hook for others' misdeeds. Communicating your responsibilities very clearly with each other. Don't commingle your tasks. Commingling tasks, that's a great way of kind of stepping in it, all right, in terms of your resourcing, your tools, your equipment, your objectives. That's what mutual agency is, when you're in there and you're working together and sharing resources. You don't want to do that if you can help it. I'm not saying you can always help it. I'm just saying these are helpful tips so that you can make it crystal clear when the inspector shows up, that company's doing that company's doing that. You want to be able to make that clear during the inspection. So, checking on, okay, safety, developing the safety expectations. This is a list. I can shoot this to you, but who has the license? Who has the expertise here in this mix? Who has control? Who's supervising who? Who's overseeing the operation? Or what part of the operation are they overseeing? You've got to make sure your employee discipline. That guy's doing something wrong. Who's disciplining him? You got to know in advance. And if you're not the one to discipline, you can at least drop a dime. Making sure everybody has their safety and medical intervention plans. What are the safety expectations for the premises generally? How do you notify a breach of OSHA, if there's a violation? How do you notify? Who's responsible for notifying who? And I would say, make sure each contractor has their own first aid training. First aid is kind of like the seatbelt violation now. OSHA won't necessarily come after you if they see you without first aid, but they hit you with it as a secondary offense while they're there. They always tag that on, kind of like hazmat. But, so, make sure they know, look, you've got to have your first aid training. You've got to make sure they know what their duties are. Check, so this is a list here, just things to check on your subcontractors, folks that are working under you. Do they have their license? What's their reputation? What are their competencies? Have you been clear with what they're supposed to be doing? OSHA likes clarity, clear relationships. It doesn't like blurred lines in terms of your responsibilities, in terms of the direction you're going in. It likes to know. OSHA doesn't like muddied waters. They want this to be really crystal clear. They want the lines very delineated. And when you bring in subcontractors, you probably know a lot of them. If you don't know one, you can trust, but verify. Get the certificate of insurance. Call around. There are associations just like this where you can get the reputation of subs that you use. This is such a great time. I love these conferences not because you come and listen to people like me talk. You talk among each other, and you connect about the real things that you have to deal with every day. Share that knowledge with each other about subcontractors working for you so you know which ones will get you in trouble and which ones are going to help you. Of course, OSHA doesn't want unabated hazards. That's the one thing they hate the most. Usually they could care less if they get a single dime in penalties. Sometimes they do, depending on where you are. But everywhere, OSHA wants abatement. They want you to correct the hazard. And take other measures to protect these guys if you are not the one who actually abates. Oh, record keeping. Always a changing picture. And now you saw they're changing how the electronic record keeping is being done. I feel bad for you guys with the whiplash between administrations. First they want everything. Now they just want the summary log. It's kind of a mess, but that's what happens. So you're keeping the records of employees who you supervise day to day. And especially if you're a GC or a prime sub, then you are recording and reporting the injuries and illnesses that occur at your work site. Now, of course, many of you have projects going on at multiple work sites. How many have multiple projects at multiple work sites simultaneously? A few? Yeah. So if there are work sites where the work is going to endure a year or more, then it's okay if they should probably have their record keeping right there. If there's a lot of quick jobs all over the place, then you can have it at a central headquarters. So keep that in mind. But if you have day-to-day supervision over someone else's employees, if OSHA deems that they're really covered by you, if you're the one in control, they may turn to you and ask you for the OSHA 300 logs on them. So make sure that you establish procedures for reporting them and recording them, especially on the report. Because if OSHA doesn't get a report of an amputation or a fatality or a hospitalization, and someone says, well, that guy was supposed to report it to you, or that one, and you don't know, and nobody does it, that's not a good day. So just making sure that's really clear. That's important. Let's see. Oh, I dropped that in there to let you know where you can find the, check the 1904, that has the requirements for recording, and just be familiar. And they're written in a way that give you scenarios and examples, so it's pretty readable for a bunch of regs. And if not, at least check the OSHA guidelines. So, your takeaways, just know, am I controlling? Am I exposing? Am I correcting? What kind of an employer am I? Or am I an employer? Do that analysis. Know in advance. For the employees, all those contractors working at your site, just know who is doing what, where, when, who has the expertise, and if to the extent that you can, make it clear who's doing what and have them be as separated as possible. Check on your subs. Ask around, not just in terms of the license, not just in terms of their OSHA history, but what do folks in SAIA say about this sub? Is this someone I should use? What was your experience? When you bring in subs, make sure they're doing the same kind of diligence on their subs and make it clear in the contract what your expectations are. So you recognize the liability for your acts of your contractors and just make sure that you have record-keeping compliance. With that, I have 60 seconds, don't I? And I have a few more of those scary-looking squeeze balls. Who has it? With that, I hope I didn't scare you guys. Can I answer any questions for you? Yes, sir.
When there's an injury or death on an accident, is there always a citation?
No. No. And they show up, of course, but workers' comp is more about taking care of employees who are hurt on the job, and OSHA is more about fault, the existence of a hazard. So you could have someone get hurt. I have a client, and it's a large trucking company, and it has guys having heart attacks like once or twice a week, and they're reporting heart attacks. I mean, I had it. You just have someone who people die at work just as much as they die at home or wherever else. So you can't have an injury without a OSHA hazard or OSHA liability, and vice versa. So, did I have a question back there? Are we awake? All right, well, I'll be here if I can answer any questions, and I left my contact information with you in some folders over on this side somewhere. And they're in the back corner? Okay. And yeah, if you'd like a copy of the presentation, let me know. And thank you so much for having me.